Good afternoon, this is Sean Golding with Golding & Golding. Each year we normally provide an article for our readers, for other attorneys, to understand what some of the more common issues and errors are when it comes to the streamlined filing compliance procedures, domestic and foreign offshore. This year we thought we'd also include an updated presentation in case you don't have the time or the inclination to want to read the article. So what are the streamlined filing compliance procedures? Well, in 2014, the IRS developed the standalone streamlined filing compliance procedures, which is used for U.S. persons to report or disclose previously unreported accounts, assets, investments, and income from abroad. There's various different types of assets and accounts that need to be reported. You got bank accounts, investment accounts, mutual funds, life insurance, pension, et cetera, et cetera. To report these assets, the IRS developed a plethora of different forms. You've got the FBAR, Foreign Bank and Financial Account Reporting. You got FATCA, Foreign Account Tax Compliance Act. You got Form 8938, which is in conjunction with FATCA, 8621, 3520, 5471, et cetera, et cetera, et cetera. So in order to get into compliance, if you haven't filed in prior years, one of the better ways to do it if you qualify is the streamlined filing compliance procedures. And those procedures are broken down further into the streamlined domestic offshore, streamlined foreign offshore. They both refer to assets that are overseas. It's just streamlined domestic is for non-foreign residents, streamlined foreign is for foreign residents. And so in order to qualify under either program, you have to be non-willful. Let me take a step back. It seems pretty simple up front to people who don't specialize and aren't board certified. This isn't the only thing that they do, right? You got to be non-willful, great, right? Kind of a touchy-feely totality of the circumstance test. If you're a U.S. resident or a foreign resident, will determine which program you qualify for. Under the streamlined domestic, you only can do amended returns. Under the streamlined foreign, you can do original returns, because streamlined foreign is for people who primarily live overseas, accidental Americans, expats, and stuff like that. Under the streamlined foreign, you get a penalty waiver. Under streamlined domestic, you pay 5%. Seems pretty simple, right? You would be amazed that over the 9 years the program has been in existence, 8 to 9 years, we've handled thousands of them, and people come to us weekly with the same common issues, with the same attorneys who purport to be experts. This is all they do, and obviously it's not. So let's go through 5 of the more common issues that we've come across in 2021. 1, not everyone is non-willful, right? There's no bright line test, and plenty of people will qualify for non-willful. And just because you read some fear-mongering article online, that had you second guess yourself, that doesn't make you willful. But you have to be non-willful. So if you're willful but super duper apologetic, well, that doesn't make you non-willful. So that's an important distinction, okay? Second is overwriting the certification. There's people online talking about writing 20 or 30 page dissertations. No person at the IRS wants to read a 20 or 30 page dissertation. In fact, if you write something like that, chances are you're going to start writing items in there that aren't necessary to put your position forward that you're non-willful, and you may write yourself into a circle, it's called, and end up coming across as willful when you were non-willful. Third is miscalculating the penalty. And this happens more often than you would think. 2 very common situations. Something like an RRSP, Registered Retired Savings Plan in Canada, not penalized under the streamlined domestic. Streamlined foreign, there's no penalty. Streamlined domestic, it's a 5% Title 26 miscellaneous offshore penalty. But the RRSP and the RIF, those are from Canada. Those are exempted from reporting. Not from reporting, from penalty. Also, certain rental properties also excluded from the penalty base. If you have rental property in a corporation and then you're trying to determine the value of the corporation, you don't remove the rental property from that value. But if it's individually owned, it's not subject to penalty. Individually owned real estate is not reported for FATCA. It's not reported for FBAR. Income is still reportable even if you have a negative net income on Schedule E. Lack of IRS follow-up and response. This is nuts, right? But this happens. People come to us and they go, hey, we submitted the streamlined and they didn't do like a flat fee full service model. And so the IRS may have come back with some questions, concerns, inquiries, et cetera, and the attorney doesn't want to handle it, right? Because it's hourly and the client doesn't want to pay the attorney for more hourly. On the flip side, the CPA, there's no attorney-client privilege. the CPA, probably wants to get paid as much as the attorney at this point. They don't want to deal with it either. It's after the fact. It's not part of the full package. And this can lead to a person getting audited. We've seen it before. The fifth and the most important is divulging the attorney-client privilege. What a lot of firms will do is they'll just hire any outside CPA that they can get for the cheapest fee, least expensive fee. There's plenty of wonderful CPAs out there, but some of them don't do offshore disclosure, of course, right? But the firm will use them. They'll enter into a COVEL letter to prepare these tax returns. COVEL letter does not provide any protection for the tax returns. And then the taxpayer ends up having more communications with the CPA than they're having with the attorney. And so, they'll start like any normal conversation, right? You start talking about the CPA. Hey, what do you think of my case? Well, the attorney said this and that. And next thing you know, the person gets audited. And then guess what? There's no attorney-client privilege with the with the CPA. And now the IRS can go back to the CPA and ask them questions. And anything that you talked about with the CPA regarding the tax return preparation wouldn't be covered under the attorney-client privilege because COVEL doesn't cover that. If you're considering doing the streamlined procedures, talk with an attorney, talk with several attorneys, use a board-certified attorney, or at least talk to a few of them so you can get the lay of the land, and hopefully you can avoid these sort of errors. Streamlined is only one of various non-willful disclosure programs. There's also the delinquency procedures and reasonable cause. If you don't think you qualify for non-willful, there's something called the Voluntary Disclosure Program as well. My name is Sean Golding with Golding & Golding. Thank you for your time. Enjoy the rest of your day.